Right. Our next session is titled Making Sure Criminals Pay, New Strategies for Fighting Economically Motivated Criminals and Recovering Their Ill-Gotten Gains. We're very fortunate that we have Professor Barry Ryder, OBE, who's come here to speak to us today. Barry is a celebrated academic and speaker. I can read a little bit of his CV, which I have in front of me. He's a barrister, master of the bench of the Honourable Society of the Inner Temple. He's a professorial fellow at the Centre for Development Studies, University of Cambridge, sometime fellow commoner, sometime dean, fellow and tutor of Jesus College, Cambridge. He has an enormous number of qualifications and titles, which I won't read out to you, but I'd like to just introduce Barry. As he goes through, he says he's very welcome to take questions as he goes, so please feel free to interrupt. He's not going to be upset, so he says. So if anybody's got any questions, just put up a hand and ask them as Barry goes along. So I'll hand over. Barry.
Thank you very much, and thank you for inviting me. It's great to be back in Beirut. I've had the privilege of being here, I think, on 3 or 4 occasions in the past, but I've never actually managed to get outside Beirut, so perhaps one of these occasions I will try. But it's tremendous to be here, and I'm very grateful to the ICC and SS Law for extending the invitation to me. In fact, I had the privilege of speaking to FRAUDNET, I think about 14 years ago, and it was in a room in London, and I think there was 8 members there. So you've certainly expanded. And of course, I'm very pleased because it means that the 8 that were there, if they're here today, will be the only ones that hear the lecture again. No, it is a great honor to have the chance to address you this morning. It's also a little awe-inspiring as far as I'm concerned, because usually when I lecture, I'm lecturing entirely ignorant students. And they've got no idea what I'm saying, and I could make it up as I go along. The difficulty is, I think, here, is that virtually everybody, apart from the waiting staff, know more than I do. So I'm also, of course, you're from such diverse backgrounds as far as law is concerned. And of course, that is one of the main issues, that we look at issues differently depending upon our legal heritage. But that's something I might come on to later on. Now, I'm very keen that, if you want to go to sleep, fine. We won't try and disturb you. But to try and avoid you all going to sleep, I'm very happy for people to shout out questions, observations, to express the view that I'm talking a load of rubbish as we go along. But I will also take questions, if there are any, after the presentation. So I'm very much in your hands on this. Now, the topic, and I'm slightly reinterpreting it, is really concerned with promoting integrity, promoting the standards that we all say that are vital for international trade and business. I should enter the caveat at the outset that there's very little empirical evidence as to the effect of many of the things that we've been talking about already this morning: corruption, fraud, certainly things like, when you get exotic like insider trading. Very little empirical evidence as to how much damage, if any, it actually does do to business. And of course, I should say, as I'm an academic, that there are those who argue that a bit of corruption greases the wheels and makes everything work. Now, I don't subscribe to that view. But let me say at the outset that it's a great privilege as an academic being asked to address all you practitioners. But the academy throughout the world hasn't made much of a contribution to this area. There are very few academics that really look at the issues of fraud and corruption and money laundering. I mean, for example, in the United Kingdom, I would think there's probably less than 5 people that actually work in this area. And it's not a lot different in the States. You know, one can think of about 12 people. When one goes to the developing world, very few. So there's not a great deal of learning in this area. A lot of it is guesstimating, speculation. Let's take, for example, the issue of asset removal. And I'm using that term advisedly, and I'll come on to why I'm using it advisedly later on. But in the United Kingdom, and you know, we reckon ourselves quite good at doing things with law. You know, we can stop prime ministers in their tracks. But we've had appalling results, really, in using the criminal law to interdict the proceeds of crime, or criminal property, the wider concept. If you, and again, we don't know what we don't know, but there are those. For example, there was a Cabinet Office document released a few years ago, which indicates that at best, we're taking out of the criminal pipeline 0.601%. And if that's our primary strategy in dealing with economically motivated crime, and when you consider the burden that the system puts on those who mind other people's money, in other words, the banks, then there surely has to be some justification beyond asset removal in justifying those costs and justifying the vast amount of resources that are put in to asset removal. Now, having said all that, a very good place to start, and something that was mentioned this morning, the United Nations Convention Against Corruption, which I think is a very important document. It's one of the few international instruments which actually does make a difference. I don't think, and I had the privilege of chairing one of the initial enforcement committees of the, before UNCLAC actually was passed into treaty status. I don't think it's in any way come up to our expectations. Days are still, we're still young in its history as a treaty, but the important thing with the United Nations Convention is that one of the most important principles is asset removal, going after the assets. And that really does throw up straight away a bit of a paradox, because governments, when they talk about asset removal, are talking about making sure crime doesn't pay. For example, I mean, Tony Blair, when he was Prime Minister, said that it should be a cardinal principle of any criminal justice system to make sure that crooks don't keep their ill-gotten gains. A moral principle, a moral precept. You know, and indeed, I mean, even if you look in Islamic law, one sees that concept coming clear right through, that criminals should not keep their ill-gotten gains. But that is a very different principle than, for example, the notion that we should restore to victims monies that they have been deprived of. Even more so it is, and we use the same law for all this, even more so when we focus on financial and other transactions as a tool of international law to reinforce international diplomacy. The problem is that the buck stops in regard to all these approaches, whether you're taking a public law approach to go after criminal property, or you're taking a restitutory approach in the sense of going after insolvent assets, or you're seeking to make a plaintiff whole in a fraud case. The buck stops with those who mind other people's wealth. And as was said this morning, it's the banks where the money is. And I think we've got to be a little careful. If you look, for example, at the media in the West, I say that because I don't look at the media anywhere else. I'm sure it's the same elsewhere. Who have we actually hammered over the last 6 or 7 years since the subprime crisis? Who's been in the dock? Who do people, for example, in the United Kingdom that you ask think are the crooks? Sadly, they're going to say the banks, because every newspaper you open, you'll see reference there to regulatory action against banks for not money laundering, not primary or predicate crime commission, but for failures of compliance. And what we've done is to shift the perimeters. We've shifted the war, right? You know, I remember years ago being told, well, there's not really much point as a prosecutor going after successful fraudsters, because by the time you discover the fraud, the crooks will be sunning themselves on Copacabana Beach and the money will all be locked up in Liechtenstein and Stats. Well, I think we've moved quite away from that. But the reality is, in this area, that increasingly we are going after, as a matter of public policy, our governments are going after as arguably soft targets, but also as they have a responsibility to ring-fence the economy. They have a responsibility to ensure integrity of transactions, the banks, because that's where the money is. So I think that banks are in a very difficult position in regard to the topics that we're discussing. They are in the front line. Now, as far as lawyers are concerned, and I appreciate my hosts are lawyers, is it good business to focus on assets? Well, I've been involved in 2 major city law firms in trying to develop asset recovery teams. And I must say that it's been precarious. I do a lot of work for China. I do a lot of work for the Chinese government in asset tracking and asset recovery. The real problem, though, is getting paid. And that is the crucial issue. If one moves away from the governmental interest in this area to making sure crime doesn't pay, to the area of restitution and recovery. Because governments, sadly, there are exceptions. We heard about the STAR program, Stolen Assets Recovery Program of the World Bank earlier on today. But on the whole, governments are not so concerned, unless they are the victims themselves, in going after assets. They're much more concerned for a medium to short-term fix. One of the problems I think we have today with governments, and I certainly don't know what the position is in Lebanon, so there's, you know, I'm really talking about the experience of countries I've had, China being a notable exception, because once you get into government in China, you stay in government for the rest of your life. But in many countries, the attention span of governments is about 3 years. That's how long, on average, ministers stay in the same portfolio. So you don't get the commitment from governments to invest long-term in asset recovery unless it's something that they really need for political purposes. So where's the business for lawyers? Well, of course, there have been some very, very successful and impressive asset recovery cases, not least by members of FRAUDNET. And I think it's absolutely right, and I'm not just saying this because you're here. I think FRAUDNET's reputation in identifying, tracing, and recovering assets is second to none as an organization. So I do congratulate you. But you are the icing on the cake. the vast majority of asset recovery cases that I've seen have not ended in impressive recoveries. And therefore, I think it is important for lawyers not to be turned off this area of concern, because there are some very, very important support areas where law firms can make a major contribution. Risk assessments, risk management, the whole area of compliance and monitoring has been an entirely new dimension that's developed largely on the back of anti-money laundering laws over the last 10 to 15 years. And certainly the very large firms make a great living out of focusing on those issues. Now, I've used the term economically motivated crime. I've not used the term fraud. I've not used the terms corruption. As someone who, in a professional context, I see myself as an investigator rather than as a practicing lawyer. Most of the work I've done for foreign governments has been at the investigative stage rather than the legal, judicial stages. And as an investigator, I think it is quite clear you can distinguish between activity which is economically motivated and activity which is not. And that is the way, frankly, most government agencies today are looking at these issues. And of course, historically, that's why we're in the position we're in with regard to anti-money laundering legislation and terrorist finance legislation. Because the first economic crime to actually generate this type of interest and legal response was not fraud. Sadly, we're hopeless at dealing with fraud in most jurisdictions. It was drugs trafficking, because people engage in drugs trafficking to make money. When the Americans realized that whatever they did, there wasn't really much evidence that supply and demand to homeland America had actually been influenced by law enforcement action, they developed a new strategy, a strategy to run parallel with their other strategies, and that was essentially epitomized by the Bank Secrecy Act 1970 and the concerns and the structures that gave rise to in dealing with asset interdiction in the widest sense of that word, and of course the corollary anti-money laundering legislation. It's interesting, for example, in my own jurisdiction, the United Kingdom, that we actually enacted laws allowing the confiscation of criminal property, initially in regard to drugs and a couple of years after that in regard to all serious crimes, before we had actually anti-money laundering legislation. And there was a view in Scotland Yard that making or developing a strategy that was predicated on removing the benefits of crime would inevitably have the result of creating money laundering. Because if there was no realistic prospect of depriving criminals of their ill-gotten gains, why should they move out of their comfort zone and engage in money laundering? Why should they incur the risks, the costs of engaging in money laundering? The only substantive risk facing them if you don't have anti-proceeds of crime legislation is other crooks. So we incentivized criminal networks in Western Europe to go into money laundering. And subsequently, of course, we enacted anti-money laundering legislation. Now, the reality is in law enforcement internationally, and of course the debate is distorted by the experience of the United States, which have invested a great deal of time and effort in going after the proceeds of crime, and relatively not particularly successfully. That has distorted, perhaps, our fundamental inability as lawyers to render those that engage in economically motivated crime accountable. We in Britain have had a series of really disturbing revelations in the last 3 or 4 weeks. Our main or lead policing organisation in Britain concerned with fraud is the City of London Police. The City of London Police really is the only force in Britain that specialises in fraud, and they effectively subcontract the initial reporting of complaints to an organisation, a private sector organisation called Action Fraud. And some of you who I'm sure will have seen the newspaper articles which indicate quite clearly that something that we've all suspected, that Action Fraud bins most of the reports of fraud that it receives. That only something like 2% of reported fraud in Britain actually gets taken at all seriously. 3 years ago, a newspaper article, the Financial Times, reported that in the year 2014, there had been over 136,000 complaints to the police about business crime in the Greater London area. A year later, that had led to 9 convictions. So we ain't very good at dealing with something as basic as fraud. In 1986, the British government appointed one of our leading judges, Lord Justice Roskill, to look at how we could better deal with fraud. And he, in paragraph 1, page 1 of his report, said that the public no longer believes that the criminal justice system is capable of bringing the perpetrators of serious fraud expeditiously and effectively to book. The overwhelming weight of evidence that this committee has considered confirms the public is correct. Now, we've had a great burst of legislation over the last 20 years, because politicians, if there's a problem, what do? They enact another law. We've got tremendous increase in, or tremendous attention has been given to legislation and to things like international cooperation. The reality is it hasn't made a lot of difference. And in all systems, there is a reason for this, or a set of reasons. And I'm not going to go through them all. In fact, I did write a paper which I think is available or will be available to you. But, you all know them as people who are practitioners in the area or who work in the financial services industry. The complexity of the matters. I mean, if you look at, there was a mention this morning about official agencies. I mean, in what jurisdiction in the world do the police have the training, the expertise to investigate crimes that occur in complex environments, in banks, financial institutions? Because don't forget, I mean, apart from the street frauds, which are serious because they're the ones that actually impact on our grandmothers and families, but forgetting those, who actually and where are serious frauds committed? Well, they're crimes of the elite, as criminologists would describe them, crimes of the powerful. I mean, it'd be no good me deciding I could go out and mug an old lady this afternoon, but I couldn't go out and commit the crime of insider trading. Sadly, no one's ever offered me a bribe because I've never had any privilege. So we're dealing with elite crimes. We're dealing with people who are elite within society, and that immediately throws up an issue. We can say that it's a particular issue in developing countries. It's a particular issue in small countries because everybody knows each other. No one wants to rock the boat. That's why when we have these cases, they tend to be as a result of new government coming in or there being a change of management in a company. And of course, that throws up a political dimension, particularly if you're engaged in going after officials in a previous government. That does cause issues for other governments in terms of cooperation. So we're dealing with complex and elite crimes. We're dealing with law enforcement agencies that really don't have the resources, don't perhaps have the priorities. And of course, I will mention this at this stage. What has been our response to that? Well, again, bearing in mind politicians have a short attention span because they're not in office for very long. They need to fix the problem. What do? They set up another agency. And one of the problems that I see in this area is fragmentation of response, particularly in the public sector. That we have anti-corruption agencies, we have specialist fraud agencies that are set up outside traditional law enforcement to address these problems of resource, training, education, perception, accountability. So you get to a situation, for example, in China, and these days I spend as a lawyer, most of my working time in China. The anti-corruption campaign of President Xi. Well, in fact, it wasn't actually President Xi who started it, it was President Hu Jintao. But President Xi certainly carried it on. And in one sense, we have to applaud what has been achieved in China. But most of the results, most of the scalps that have been taken in terms of the crusade against corruption in China have not been through the legal system. They've been through party discipline. And that throws up a big issue in terms of the rule of law and issues of accountability. One of the problems the Chinese have is that as a significant proportion of the cases are not brought as criminal prosecutions, they're brought as a matter of party discipline. The results can still be the same, very serious results. But where does that fit into terms of international cooperation? And one of the difficulties we've had in creating specialist units, specialist agencies, is the fragmentation of law enforcement and the problems that that causes in terms of international cooperation. But of course, there are other issues in regard to fraud and economic crime, which have all militated against us being effective. The transnational aspect. You know, when Henry II, one of our early kings in England, was asked how far his writ ran, he said, as far as my arrows reach. The sanctionist view of law. Sadly, there are few jurisdictions, the United States being one of them, where theories of jurisdiction have kept up with developments in ballistics. The Americans do go where their power resides. You know, for example, you take Mr. Noriega, who had an early morning wake-up call from the US Marine Corps and was put in the back of an American transport and, of course, found himself in Miami for a district court, and he raised the issue of due process. And the American federal court said you can have all the due process that you want. Now you're in the United States. You know, but there are few countries that are prepared to do that, that are able to do that, are willing to do that. So the transnational aspect is a problem. And of course, it's compounded by different political agendas. It's compounded by the fact that we have different laws. And although, as far as going after assets is concerned, the common law has proved to be reasonably effective, one can't say that as much in regard to some of the way the civilian jurisdictions apply their law. Although civilian jurisdictions have other mechanisms, particularly the role of administrative law. So we've had quite poor results. And that, in large measure, has resulted in us focusing on assets. I mean, I have been privileged over the years to advise or be involved with a number of governments around the world, and when you have the privilege of meeting ministers, they will say, well, what can we do? How can we make sure crime doesn't pay? How can we get the assets back for the victims of fraud? The problem is that they're not realizing that the two are separate questions. And of course, for what is perhaps, from government's point of view, the key area of criminality, money laundering, right? That almost certainly is not going to throw up causes of action. So asset recovery, the private element in law enforcement, is not going to be there. Why are assets important to governments? Well, there is, of course, the moral imperative that governments do have to say and perhaps convince themselves that crime should not pay. But secondly, there is the pipeline theory. This was recognized by Interpol back in 1976, that resources in the criminal networks are used for a variety of purposes to destabilize, to penetrate economies that have profound implications for us all. There is also, of course, the issue of restitution, which I will come on to. But there is another element today, and this is, in law enforcement, the elephant in the room. I don't know any experienced, responsible police officer anywhere in the world that would say today, in dealing with fraud and things like money laundering, their objective is to investigate or detect, investigate, prosecute, and hopefully get a conviction. Because that is all bridges too far. What they would say today, and in fact our statutory mandate of our National Crime Authority reflects this, is to disrupt crime. We don't talk about putting major criminals in prison these days. We talk about disrupting criminal networks. In regard to terrorist finance, we talk about disrupting terrorist organizations. And of course, this has profound implications, because to disrupt, and disruption is not a conventional technique in law enforcement. You know, most people in law enforcement don't think it's enough just to make it difficult or more expensive or more costly for criminals. It's a tactic of our intelligence and security services, and largely this is a result politically of 9/11. Our international mechanisms for law force, police-to-police cooperation were found wanting. In fact, Commonwealth governments recognized this. Back in 1979, Commonwealth governments, Commonwealth law ministers meeting at Sam Lord's Castle in Barbados said police force to police force cooperation doesn't work. And there's not much we can do to make it work. So let's think out of the box. And a lot of the stuff within Commonwealth countries relating to asset tracking and asset removal comes from that recognition. But what does disruption actually involve? Well, it means using all the mechanisms within the legal system. This is the should we say, the rule of law definition of disruption, using all the resources within the legal system to make it less attractive to criminal organizations to engage in activity in your back door, in your backyard. It's a classic example of persuading criminal organizations or people you don't like to go somewhere else, to go and use another bank or to go and use another jurisdiction. And the problem with disruption is it generally, as a strategy, occurs outside traditional law enforcement. You don't know what you don't know, so you don't know how effective it is. It is politically unaccountable. I know, because I used to run a governmental unit. Its mandate was disruption. And in the end, we were so good that no one thought we did anything. So the more successful you are, the less the media get to hear about it. So you're forced more and more away from all the values that I'm sure you as lawyers have. You move away from notions of the rule of law. And that's a real issue. And I can tell you, in disrupting criminal networks, you don't generally get the results that you need as quickly and as timely and as cheaply as you need through the use of the criminal justice system. Of far more importance is regulatory intervention through regulators and through the tax authorities. It is also, I think, important to distinguish, when we talk about criminality, between two very broad areas, and that is crimes such as fraud, which generate wealth, generate illicit wealth, whether they be described as primary crimes or predicate crimes. But we don't tend to focus on those because they are the too difficult category. We focus on facilitative crime. The discussion so far this morning has been about money laundering and corruption. Well, you don't do money laundering just for the hell of it. You don't go out and corrupt people for the fun of it. They are facilitative. And that's another issue that I think as lawyers sometimes we forget, that these crimes are facilitative, usually of something which is far more disruptive and dangerous to our societies. And there is a danger that we focus on those facilitative aspects. And that, of course, is why policemen don't like us. Well, because, of course, we get paid better and we travel around the world and all that, and they're lucky if they get to go and speak to somebody in the next policing zone. But they don't like us because they think that at best we are licensing serious crime. We are at best taxing crime. We are at best, as regulators, licensing, or not licensing as the case may be. We're not actually making an impact on that category of primary predicate crime. Now, of course, the answer to that is, well, why do people commit these crimes? They commit these crimes to make money. And therefore, we, as lawyers concerned with asset recovery, asset removal, we are actually attacking not just the motivation of the crime, but we are attacking the ability of criminals through the criminal pipeline to reintroduce that wealth, to use that wealth for criminal purposes, as subversive purposes, political purposes, to cover their tracks with corruption, bribing judges and all that. We actually are making a difference. So that is why it is right and proper to impose by law and by good practice and by FATF and all that's good in the world, these obligations on banks, to actually shift legal risk onto banks. That's why it's good. And then the obvious question is, well, how much money do we actually take out? Do we actually make any difference? And the answer is no. You can still buy drugs in London now cheaper than you could have ever bought them. If you actually look at the amounts of money, even the STAR initiative and the World Bank, and of course they've had a lot of very great success recently in regard to the fallout of the Arab Spring. But if you actually look at their official documents, they're saying, well, it's all actually very disappointing. We've actually taken out very little. So what can we do about this? How can we re-level the playing field? Well, I'm just going to list some of the things that governments are thinking about. The first is the issue of culpability. Now, generally speaking, as lawyers, we don't like imposing serious liability, certainly liability that affects your liberty, or may deprive you of significant amounts of property. We don't like imposing that consequence other than on people who are dishonest. And the general threshold of liability is proof and a very high standard of proof, proof beyond a reasonable doubt, of dishonesty. Now, my view is that if you can go to prison for negligently driving a car, shouldn't you be at least at risk of going to prison for negligently driving a bank? Right? Well, I'm glad to say that in the United Kingdom we did enact a law which says that. It doesn't do that because obviously the City of London objected to that. So what we've done is to introduce, and the lawyers will appreciate this illogical concept of gross negligence. I mean, you're either negligent or you're not, and in most systems of law, negligence is judged objectively. It's not a subjective standard. So probably the offence that we've got in Britain, which is a bit like closing the door after the horses have long gone, because it's only when the bank goes insolvent is it relevant, and that is basically the reckless involvement in the management of a bank that goes insolvent. But we are thinking, I mean, I know the government is actually thinking, well, I don't know where we've got a government, I haven't looked at the news this morning, but Mrs. May's government was thinking, and this may shock you, of making money laundering a strict liability offence. So you don't have to prove any state of mind. Now, isn't that rather shocking? We're talking about criminal liability. We're not talking about, civil liability that you can negotiate out of. We're talking about criminal liability. Go to jail, go straight to jail liability. Strict liability for money laundering. Well, we have that effectively in regard to corruption. Section 7 of our Bribery Act, and we should not extol the virtues of English law because Britain has had an appalling record in dealing with corruption. But the Bribery Act is a very interesting piece of legislation. Section 7 of the Bribery Act says that if you are a British business and an agent of your business, for the purposes of your business, bribes a public official anywhere in the world, then the British business, the British company, is automatically criminally liable. Unless it can prove, the burden goes on to the company or the partnership to prove that notwithstanding what in fact happened, that it had put in place adequate procedures. In other words, it had done a proper risk assessment and had put in place specifically designed compliance procedures to address that risk. So good compliance, this is why all the lawyers, all the big city firms are rushing into this, because it was all very well saying to banks, oh, well, yes, you've got to have compliance because these guys in Paris tell you you've got to have compliance. But when you say that you're at risk from any agent of yours anywhere in the world, and the only defense is going to be that you actually can demonstrate tailor-made compliance, tailor-made monitoring, tailor-made training, that's a different marketing strategy. And that approach has been extended by our Criminal Finances Act 2017 to tax fraud. So any British business that facilitates tax fraud anywhere in the world will be automatically criminally liable unless it can prove that it had put in place compliance procedures. Now, there is a strong and growing element within the United Kingdom, and goodness knows it would be only a fool that would try and predict anything in Britain these days, but there is a compelling political force saying we should extend that approach to all money laundering. So wherever money laundering takes place, then there would be the prospect of automatic criminal liability unless you could actually prove that you'd put in place tailor-made, as proposed that risk, compliance, and it stood the test. So that's one area that I think we are going to look at. Corporate crime and corporate sanctions, a big issue. We all know that companies have separate legal personality. Well, first of all, is it worth holding companies to account? And this gets back to my very early comment about who do we punish for failures of compliance? Who do we punish for getting involved in financial transactions of people we don't like? Well, we punish the entity, don't we? We punish the bank. And how do we punish banks? We fine them. So we're actually, it's a bit of an own goal when you think about it, isn't it? Fining a bank for conduct that probably occurred 2 years ago, so the management have moved on. So who are you actually fining? Well, you're actually harming the stakeholders, aren't you? You are bringing into disrepute the engines of your economy, your financial intermediaries, your banks. We're also concerned about investor confidence and confidence in the banks. So what do? We create all these new laws, and then we go after the banks. And of course, in the media, we don't often articulate the differences between being involved in a primary crime, defrauding investors, for example, and merely facilitating perhaps one's client's attempt to launder the money. So the whole issue of corporate responsibility, so there is a move in some countries to see whether we can actually, in many more circumstances than we have in the past, cut through the corporate veil and go after the individuals, because at the end of the day, companies do act through individuals. Another area is whistleblowing, and of course, incentivized whistleblowing. I mean, one of the interesting provisions, of course, in the Dodd-Frank Act in the United States, which was very much kind of a rerun of the New Deal, Obama's New Deal, in dealing with some of the problems that arose out of the subprime scandal, was the provision, or is the provision, that if you give information which results in regulatory action resulting in a financial penalty, then you can be awarded up to 30% of that financial penalty. So incentivizing whistleblowing is an area of particular interest. But the three areas that I particularly wanted to focus on are control liability, facilitator liability, and actually forgetting all about money laundering and just going after unexplained wealth where it materializes. The Americans developed notions of control liability right back to the Securities and Exchange Act in 1934. And we're beginning in other common law countries to consider that. I've already mentioned Section 7 of the Bribery Act, but it does provide a useful mechanism for putting beyond debate the responsibility of those who handle other people's wealth to put in place adequate procedures. A much more interesting area is facilitator liability. I mean, if you spoke to the head of our National Economic Crime Command, his ambition is, before he hands over or retires, is to put some senior partners of Magic Circle law firms in prison. Because his view is you don't do any of the things we're talking about unless you have a tame lawyer and a tame accountant. And there are a lot of law enforcement agencies around the world today targeting those who facilitate. Now, of course, facilitation is an interesting issue, and there is a civil dimension to that. I don't know whether I'm going to have time to address that, but I will if I can. But perhaps the most interesting recent development in common law countries has been, well, it's all very well saying that we're there to, the law's there to promote integrity. We want to discourage corruption. We want to discourage all this acquisitive crime. But the reality is we need a predicate crime. We need to be able to investigate. We need, at least at a probative level, to be able to tie up the two and show that it's dirty money. So why don't we just go after unexplained wealth? I can remember years ago being on a podium like this in Indonesia, and all the people in front of me were senior customs officers. And I said, I understand in Indonesia you have the best customs service money can buy. Rather like they used to say about the Royal Hong Kong Police Force. They all looked a bit surprised with that comment. And I said, look, and they were all generals and colonels and all that. And I said, look, you all know, I said, take a sheet of paper, put it in front of you, please, and put the rank of the person sitting to your right. So they all, I said, you all know how much somebody at that level earns. I said, put that down, you know, ballpark figure. They put that down. I said, now, would you all do that and put an estimated valuation on the watch he's wearing? I said, you all know the cars that you came to the... Well, that's when I was taken off the podium. And I didn't go back to Indonesia until I went back with the US Treasury team 3 years later when the Indonesian economy collapsed. So what we're talking about is unexplained wealth. Now, of course, there are some issues. I mean, I do a lot of work in South Africa, and of course, one of the priorities in South Africa is, one way or another, to empower the movement of wealth. So there is a lot of wealth surfacing, which is pretty unaccountable. But there are, and of course, there are constitutional objections in some countries about going after unexplained wealth. But we have new legislation, again in the United Kingdom, going back to the 2017 legislation, which provides that if you are a politically exposed person, and most of my friends want to be politically exposed, but if you are a politically exposed person, or there is reasonable grounds for suspecting that your wealth is the product of criminality, and it is in excess of £50,000, then the authorities can serve a notice on you asking you to explain where you got it from. If you lie, that's a criminal offence. If you don't say anything, which I'm sure most lawyers would, in other circumstances, advise not to, if you don't say anything, the matter can be referred to the court, and effectively your wealth can be confiscated. Now, there is argument that we should attach to that restitution provisions, because one of the problems in making the law more effective in making sure criminals don't keep their money is that that doesn't do an awful lot for victims. And certainly in the developing countries I've worked in, there's almost been a reluctance on the part of even governments to notify other governments, because there is a fear that those other governments will seize the ill-gotten gains in their banks and in their financial institutions, and they will go into consolidated government funds, and that would be goodbye as far as the developing country is concerned, the developing claimant. And of course, these are addressed, these issues, in regard to corruption in the United Nations Convention. But still, there is a feeling in many parts of the world, including China, that it is actually better to go and negotiate with the crooks and get something back than get token payments, possibly connected to development aid and a political, and be subject to a political agenda. Now, I don't agree with that, but that is something that we need to address. And of course, that is also, to some extent, a bit of a problem with any asset-focused initiative. First come, first served. How do you actually prioritize recovery? When we look at the civil law, again, is seen to be perhaps a useful tool, and governments often talk about, I mean, Sri Lanka's just about to enact legislation which will greatly increase the reach of the civil law, but what they're really talking about is not restitution and victim support. They're really talking about using the civil law, as the Americans have done for the last 40 or 50 years, as an enforcement tool, such as the SEC does. Now, of course, more recently, in the last 30 years, the SEC has often gone after, used its civil enforcement powers on behalf of investors, but many countries have adopted, perhaps with not much understanding, the same, and I would include the UK in this, have adopted the use of civil law as an enforcement mechanism without really giving much thought to the position of victims. So the two areas that I really wanted to mention are the area of compensation and the area of restitution. When we're talking about making victims whole, then we are primarily talking about the ability to sue, the ability to identify a cause of action, and you are all the experts on that. We all know the issues. We know the problems of finding a plaintiff that has sufficient locus standi. We know the difficulties of finding a venue. We know about the problems of finding a venue that has judges that are going to be bold enough and bright enough to actually read the papers and do something about it. But we also, and this is a major problem again with China, we need to be certain that any judgment we get, any order that we get from the court is going to be enforceable. And until very recently, for example, in China, it was extremely difficult to enforce a money judgment, even by a Chinese court. So, there's some very real issues out there, which I'm sure FRAUDNET is well aware of. So it is really in the area of restitution that I think perhaps most of us have a real interest. There is, of course, in many legal systems, including the civilian legal systems, a corpus of law which allows restitution. And of course, one of the reasons why government has become interested in this area, why you will see a third of the provisions in the United Nations Convention Against Corruption relating to asset recovery predicated on restitutory concepts, is because in restitution, what you're doing is making sure the person who should not have benefited gives up that benefit. You're not so focused on the victim that you are actually, for example, if you go back to the very early equitable cases upon which restitution is based, a leading case in our jurisprudence is Regal, Hastings and Gulliver, which only last year was reaffirmed by our Supreme Court. There the principle is simply, it's prophylactic, that those who have abused their position should not benefit by virtue of that abuse, which sounds very much like the kind of things that law enforcement talk about making sure crime doesn't pay. And of course, recovery, restitution, certainly equitable restitution, is not predicated on any loss. It is predicated on the breach of the duty of good faith. And what we've seen in the last 10 years is a very considerable development in that area of law. And particularly the development of proprietary remedies. Now, I'm not going to go into this in any great detail because I want to leave some time for questions. And of course, many of you, this is your bread and butter area of practice, so you will be very knowledgeable about it. But let me just make 3 points. First of all, the development of this law and this corpus of law, and it certainly in the United Kingdom, and at any time, probably our 36 commercial courts, half of them will be actually addressing issues of asset recovery from around the world. Apart from the cost, London is still a great place to bring these cases. But they will largely be predicated on the availability of proprietary remedies. And one of the most interesting cases on this, and a case I always tell my students to read, of course law students these days don't read any cases, but is the Attorney General for Hong Kong and Reed. I know at least one of you here will remember the good Warwick Reed. I was actually on his appointments committee. He was appointed as basically the director of the Serious Fraud Office in Hong Kong, and he engaged in a number of unfortunate courses of conduct, extorting money from people who had been charged, arguably bringing false charges and then extorting money. Anyway, cut a long story short, he was sentenced to a term of house arrest, not proper prison. And the Hong Kong government wanted to go after some of his ill-gotten gains. And these had been invested in a kiwi farm, a kiwi fruit farm in New Zealand. And the Attorney General for Hong Kong brought the action, and in the end it went to our Privy Council. And it was interesting because it really related to whether you could find proprietary remedies, whether you could actually go and seize the kiwi farm, which is actually the name of his wife, and actually seize that and say that represents his ill-gotten gains, and that belongs to the Hong Kong government. So the question of tracing, because at that point in time, the tracing remedy, or tracing the right to trace, it's not really a remedy, was predicated on there being a possibility of a constructive trust. And basically, the case became before Lord Templeman, and Lord Templeman was a very great judge, and he did take the view that the ends justified the means. Equity looks as done that which should be done in contemplation of equity. Warwick Reed should have handed over this property to the government. Therefore, he allowed the tracing and constructive trust. That case led to a great burst of asset recovery litigation, which was clipped by the Court of Appeal in the Sinclair case in 2011, largely at the behest of the City of London and commercial lawyers. Because basically, if you have the right to reach out and say, that's our property, in priority of debtors, in priority of creditors, in priority of creditors, in priority of anyone, then that is likely to be disadvantageous to the banks. So the city basically lobbied strongly against that, as did most academics. And the Court of Appeal in the case of Sinclair Investments in 2011 said that no, the law should be taken back to the 19th century, and before you had access to tracing and restitutory remedies, you had to show effectively intermeddling with trust property, that the fraudster had done more than be a fraudster, had actually engaged in misappropriation of what equity would consider to be property. I'm glad to say that that was reversed in the European Ventures case, the Cedar Holdings case in 2011. And on that case now, we do have the law to go after basically assets associated with a breach of fiduciary duty anywhere in the world. And that has reinvigorated private litigation. And we've now got, and really, of course, who do you go after in these cases? We go after the banks and we go after the lawyers. Because there is a surprising case, which I think will be surprising to some of you, a case called Finders and Miro, which is still good law. It was approved by the Privy Council recently, where an American lawyer joined a law firm in London, and at a dinner in London, he heard mention of one of his former clients for whom he'd created a captive trust in the Cayman Islands. And somebody, in response to the raising of this name, said, oh, isn't that the chap who's under investigation by the Louisiana State Insurance Commission? So the lawyer knew a fact, suspected a fact, which gave him a suspicion that the monies he'd put into this trust may have been the proceeds of what was being investigated. So he goes along to the High Court, confirmed on the Court of Appeal, where Sir John Mummery, as he then was, said that where you have strong suspicion that you have facilitated the handling of funds which may be the proceeds of a fraud, then you, the solicitor, are under a duty to take such steps as are reasonable to search out who may have a claim against those funds and inform them. Now, that duty applies directly to banks in the UK, a case called A and the Governor of the Bank of England. But compounding that, we've also had recent cases which actually indicate that banks, well, we know banks have a duty of care to their customers, but they actually have a duty of care informing the suspicion that that money may be tainted. And they also have a duty of care in handling their relations with law enforcement and the regulators once they have formed that suspicion. Right. There's also, and this gets back to the very first comment I made, that we haven't really thought any of this out. There are a number of potential conflicts or uncomfortable aspects between the public law and the civil law, the private law. And one is in regard to the tipping off offence. Of course, under all our laws, where you have knowledge or where you have a high degree of suspicion that there is going to be an official investigation in regard to funds, then you commit a criminal offence if you tip off. Well, of course, the classic case in Britain is a bank that puts in a suspicion-based report to the authorities, and then the client says, please move those funds. What do you do? Well, of course, we've introduced legislation quite recently which absolves the bank if it acts in good faith. And one of the problems in the case on duty of care was that it was possible that the bank officer had not acted in good faith because she'd received a bribe, not a bribe, a payment. Not a bribe, no, or a beneficial loan. But she was held to be in good faith. It was a very good bank. So there is that situation where if you act in good faith, then you're immune from the consequences of actually making that referral. But of course, that doesn't protect you from other areas of law. It doesn't protect you from liability in equity, restitution, and it doesn't protect you if you bring the action in the courts of another jurisdiction. So there is a very big problem, and we've had litigation in Britain. The Lord Chief Justice said, well, you know, banks aren't charities, banks are in business to make money, and yes, there is a potential conflict between the criminal law, the obligations that the criminal law imposes, and the self-interest orientated duties or to avoid liability that the civil law would indicate. And he said, you know, don't come to the courts for advice on this. You know this. You know that that's one of the risks of handling suspect funds, and there you are. So I think we do live in interesting times. The areas of law that I've tried to refer you to have not been properly thought out. In even jurisdictions, you know, we pride ourselves in London as the world's leading financial centre. We try and burnish our reputation all the time, and we haven't resolved these issues there. So goodness knows when you're bringing a civil action before a court in some of the more interesting jurisdictions. I think this is an area where, frankly, FRAUDNET has made a major contribution and has an even bigger contribution to make in the future. So thank you very much.
Thank you very much, Barry. It's fascinating. Would anybody like to ask some questions? I think we've got about 15 minutes until the scheduled lunch break. Does anybody have any questions that they would like to ask Barry? Anything that's been eating away at you while he's been speaking? Nada?
You can move it if you want. That might be a good idea, actually.
Okay, well, I'll try without the microphone. You mentioned the distinction between the offense being predicated, the restitution being predicated on loss or not. Can you please explain a little bit? We have in the audience honorable judges here and lawyers, and I personally did not get the difference between restitution as restitution and the one predicated on loss.
Yes, it is a peculiarity of the common law systems, but insofar as most restitutory claims, and there's always exceptions, obviously, in the law, as in most common law systems, restitution is based on equitable principles. And the law on this is really predicated on two principles. First is which is often said to be the cardinal principle, which is that if you are in a fiduciary relationship, then you must avoid all conflicts of interest. The leading case on that is a case called Bray and Ford, a classic statement by Lord Herschel. That's the core of all fiduciary obligations, to avoid conflicts of interest. Now, jurists argue whether as a corollary of that or as a separate principle, there is a rule that if you are in a fiduciary position, then you are not, unless expressly authorized, after full disclosure, allowed to benefit by virtue of your position. It's a strict rule of accountability. And it was most dramatically set out by our House of Lords and has been followed throughout the Commonwealth in the case of Regal, Hastings and Gulliver. And that decision was expressly approved in the Cedar Holdings case by the Supreme Court. And there it is quite clear. It says, for this liability to account for any benefit you receive that has not been expressly authorized by your principal, then it doesn't matter that the principal has suffered no loss. It doesn't matter your state of mind. You don't have to be dishonest. The liability arises simply because the profit has been made. We call it a secret profit. The profit has been made by virtue of your fiduciary position. Now, it may interest you that I've been doing quite a lot of work actually on this in regard to Islamic finance, because one of the big areas of debate, and there's obviously many issues of uncertainty where Islamic finance meets secular law, is the extent to which, for example, Sharia scholars on a Sharia board would be in the position of directors. They would certainly, in most cases, be in the position of statutory directors or shadow directors, because the definition of a director is a person in accordance with whose instructions the company the board is accustomed to act. So they would be a shadow director, but whether that imports the fiduciary duties or not, I think it probably doesn't, although the Malaysians have actually enacted law specifically on this. So, to get back to your question, yes, when you are looking to fiduciary accountability, it does not depend on whether there has been loss. There is sufficient loss because the cardinal principle of fiduciary responsibility, that you put yourself in a conflict of interest by making a secret profit, has been violated. So it's in many legal systems in the United States and they call it the duty of loyalty, which is perhaps clearer. And it's the duty of loyalty which is at the heart of equitable restitution. But of course, restitution as a body of law has been developed. And in most of the statutory structures for restitution, certainly the civilian structures, then you are basically restoring loss. So it is there you would have to find loss. All right? But in the common law system, it's simply looking to take away the benefit that somebody has achieved by virtue of a violation of their fiduciary duty. So it's very wide, and of course this is why it provides such a satisfactory remedy. And there are cases which have been brought. I mean, there was one classic case from Indonesia, and of course Indonesia is not a civilian jurisdiction, it's a Roman Dutch jurisdiction, doesn't have equitable principles, but the proceeds of this corruption were put into a Singapore bank, and the courts in Singapore, which are common law courts, said the issue is where the money comes to rest. So we can apply fiduciary principles as we do in Singapore in regard to this money, and it was given back to the Indonesian government. And that principle, the Tahir case, has been used quite a lot. I mean, that's the principle we try and use in China, because obviously China hasn't got these fiduciary principles. Any other?
Professor, could you give us some voice on the question of why it is that jurisdictions like New Zealand, Canada, and the United States developed the remedial constructive trust to solve vexing problems? I can recall in 1981 being in law school in Canada and studying the Supreme Court of Canada's famous family law case called Becker and Becker, where the husband made off with family property, or the property generated during the currency of the life of a marriage. Wife wanted some of it, and the Supreme Court of Canada said, okay, husband, you are a constructive trustee for the wealth generated during the currency of the life of the marriage. And then the court started applying that to fraud cases where there isn't a so-called fiduciary relationship, because Canadian judges began to explore, well, why is it that victims of breaches of fiduciary duties may have a proprietary claim, but the victim of a pure fraudster who's just a trickster, he's not a fiduciary at all, but he's a con man and he takes the money, why can't the victim also have a proprietary claim? So my question is, why would English judges struggle with the adoption of these basically restitutionary or fairness principles about property law?
Well, unfortunately, of course, Mr. Justice Wharton, in the case of Balmoral and the Bank of England, said the common law knows nothing about unfairness. So you're absolutely right. It goes back to a case in the 19th century called Lister and Stubbs, where the Court of Appeal, the Court of Exchequer Chamber, which is equivalent to the Court of Appeal, basically made this distinction between the proprietary remedy and accountability. And of course, this has been a distinction that has served banks, particularly as creditors, extremely well. And far be it from me to say that commercial law in Britain is influenced by city considerations, but sometimes the tail does wag the dog. So that is the reason why the Sinclair case came in heavily and actually took us back to 1893. You're right in that the Australian courts, the American courts started playing around with these concepts in the 1940s, and of course now there is a remedial constructive trust in most states. Not all states, but most states, and you'd be the great authority on this one. I think this has been really where it's been quite interesting in seeing how the law has developed. And even you've got something that approaches it at federal level in the states, where you have SEC type actions under statute. Australia and New Zealand in particular did take it forward. And the difference was that in Britain we regarded the trust as a mechanism for holding property. And therefore you needed a proprietary nexus. So you had to show that there was some kind of property involved in the misconduct. Now, the two interesting areas of that were, could information be property? So the information which enabled you to commit the fraud or to engage in insider trading or to set the money laundering structure up or whatever, could that be proprietary? Well, because equity in some cases, getting back to some conversation we had earlier on, will protect that information as confidential information as it has a commercial value. So could information be property? We know information can't be property in our law for the purposes of the law of theft, but may it be property for the purposes of restitution? The other interesting case, and again it's the Canadians that cause all the confusion because all the cases are Canadian, like Peso silver mines and the like, was whether an opportunity that is exploited could actually be regarded as fez in equity, a form of property. So those were the two drivers. But I suspect now, after the Cedar Holdings case, there isn't a lot of difference between the English law and the Australian and Canadian law. The American law is slightly different, but I think today that we effectively do have a remedial constructive trust, provided you can show a fiduciary nexus not a relationship. Now, the interesting thing is where you receive property in circumstances that you know or should have known is being transferred to you in breach of a fiduciary duty, you become a fiduciary. So that is one way of reaching out, particularly as we've had the degree of knowledge that you need for that extended liability is objective. We call it naughty knowledge. It was when Admiral Nelson was in the Battle of Copenhagen, he was the number 2 admiral, and one of his officers said to Admiral Nelson, do you see the flag admiral has raised his standard? We have to withdraw from the battle against the French. And Lord Nelson put the telescope up to his bad eye and said, no, I don't see anything, carry on. And they won the Battle of Copenhagen. So we've extended it to where you where you don't ask the questions, that you should have done in the circumstances. But we haven't gone as far as imposing a constructive trust absent any fiduciary nexus.
By way of follow-up, though, English judges recently, in the last decade, have been progressive in the area of choice of law and proprietary claims. And for we in the British Virgin Islands, we struggle sometimes with keeping trials in the BVI because our Court of Appeal is very conservative about what Americans call long-arm personal jurisdiction or extraterritorial jurisdiction over defendants. And why should we have trials in the BVI when BVI company problems may concern Russians and Ukrainians or people in China, and isn't it inconvenient to have trials in the BVI? Yeah. So what we started to understand is that if you can confine a claim form and a statement of claim to a proprietary claim over property situs in the BVI, and our Companies Act says all shares of all BVI companies are deemed to be located in the BVI at the registered office of the company, then you do have extraterritorial effect on people. Our court does have jurisdiction to resolve property claims if the property be in the BVI. So in a recent case, we act for a Japanese company. It's alleged that their former CEO and chairman misappropriated value and put it in a super yacht registered in the BVI. So we've confined the claim to a dispute over ownership of the title to the yacht. Then the next legal problem we had, well, wait a minute, Japan is the root to the relationship, the fiduciary duties, and Japanese law knows nothing about a proprietary claim. So how do we mount a proprietary claim on the back of a relationship of trust in Japan? And we discovered English case law saying, aha, the solution is that if the property is in London or the property is in the BVI, of course you can mount the claim because proprietary claims spring up somehow if the property finds its way in London or Tortola, which is kind of a fascinating solution in our case to a jurisdictional issue, not a proprietary one.
Yeah, that's absolutely right. And of course, the origin of the initiative on this was the Singapore case, the Tahir case, back in the early 1980s. Yeah, there's been quite a big development there.
Thank you for this global knowledge you offered this morning, living in Beirut and trying to fight several rumors about banking secrecy. So how, with your global knowledge and the track record, would you put banking secrecy in the disruptive momentum you have already announced this morning? What's your view on it?
Well, I mean, you have bank secrecy laws here historically for a specific reason. I don't really want to address the issue in regard to Lebanon because, first of all, I don't know anything about it really, and secondly, but as a general issue, bank secrecy is generally regarded as a barrier to effective action on behalf of parties. Having said that, I think that there are relatively few jurisdictions today where you have real secrecy and you don't have any mechanisms for for that secrecy being waived in some form or another. I think when you're talking about disruption, though, and this again is one of the issues, that you don't need evidence. I mean, one of the things that concerns me, at least conceptually, is that because we are not, many countries today, their primary stance in combating organized crime, serious fraud, terrorism, is not traditional action within the criminal justice system. It is disruptive conduct, that you don't need evidence. All as you need is that terrible word, because it means so many things to so many different people, intelligence. And I think that as a lawyer should worry us. I mean, at the end of the day, Martin, when he's after somebody's money, he needs evidence. Now, it may well be that intelligence will lead him to evidence. It may be that information that's not even intelligence and information that would otherwise be of questionable value, questionable admissibility, will produce evidence. But when you move out of, and in fact, I'm of the view that perhaps today we've moved too far out of that. And it's largely been all for the reasons I've said earlier on, the incompetence of law enforcement, frankly, the incompetence historically of Interpol, the inability for us to recognize really what we're dealing with. For all those reasons, law enforcement today increasingly works on intelligence, acts on intelligence, and does not need evidence. So the extent to which bank secrecy was a problem has been mitigated. I mean, if you go back to the early initiatives by the United States and the more recent initiatives by the European Union in regard to jurisdictions that have bank secrecy, at the end of the day, it was either you cooperate or we get the information some other way. And there's always been ways to get information, which it would not be for me to be standing up here talking about. But so yes, bank secrecy, I think, is seen to be a problem. In fact, the United Nations Convention Against Corruption specifically addresses this. I think it's in Article 40. It says that secrecy should not be allowed as a treaty obligation to be a barrier to the effective investigation of corruption or the pursuit of assets associated with corruption. So there is that. But having said that, I don't think in terms of many areas of law enforcement today, bank secrecy has the relevance that it used to have. I hope that's helpful.
Yes, hello, my name is Antoine Karam. I work at the United Nations Office on Drugs and Crime, combating money laundering. Yes. I realized that I know not much about asset recovery after your lecture. It was extremely interesting, so that was really good. And also, when you were explaining about your global experiences and the natures of the crimes that you saw in every country, it also reminded me also of the things that we are exposed when we travel, and we see that every country has different challenges, and the nature of the crimes done there are different. Now, what I wanted to say is, because we also work with, from the Pacific to the Atlantic, from New Zealand to Iceland to about 51 countries until now, some places I see that the asset recovery benefits from a similar structure like money laundering. Our main, our partners, our main audience is the financial intelligence units of governments, and there's quite a few bodies that are formal or informal for them to meet and establish a framework, the Egmont Group, the FATF, and other. Many times I see that the asset recovery is also present. You have a specific unit, part of the police, part of the financial crime in governments, and in other times there are absolutely, there is no such representative, there are no bodies representing them. Because I'm not that knowledgeable in that, do you think there is an opportunity here to have kind of like streamlining between the two and more collaboration, to have similarity and to benefit from the same networks? Thank you.
Thank you. FIUs are, I think, today, financial intelligence units are probably the most important element in law enforcement, because it's the FIUs that actually do provide the mechanisms and information through which disruption takes place. Anything I've said, I wouldn't want to be construed in being critical of FIUs. The problem is, as I'm sure you're only too aware, that FIUs have different remits in different countries. Some are integrated into law enforcement, some are in central banks, some cannot pass information to law enforcement. There's a tremendous amount of variety with FIUs. And there's always the ever-present concern, I think, that financial intelligence is empowering across a very broad spectrum, including the political spectrum. And this is something that I think really is of concern. Again, it's something we have not really addressed. I mean, being able to monitor, in many cases on a real-time basis, the financial transactions of targets, whether they be corporate or individual, is a major, major issue. And it is basically this area of financial intelligence which does justify, from government's point of view, putting the burden on the banks and financial institutions. I don't think there's many in government today that are really engaged with these issues in any country that would actually justify all the burdens that are placed on banks and financial institutions on the basis of asset recovery. They would do it on the basis that it provides information which allows preventive action, allows disruption, allows a strategic activity. I think with the United Nations as a public sector body, STAR is in a privileged position with the Egmont Group and with most FIUs. I think there is, in most cases, a potential difficulty with FIUs or any governmental organization assisting private asset recovery. Where a government's involved, and it's very different. I mean, I can remember doing cases many years ago for Zambia. And what we did, we had the whole team in London made special constables under Zambian law, so we could actually receive official information. Where you can get a government involved, then the doors are open at an intergovernmental level. The other interesting thing I think there is not so much with the FIU, but the extent to which governments can act in assisting private sector litigation. I mean, there is an interesting provision, again, in the convention which allows them to do this, and also to empower private litigants. But this is difficult. I mean, in America, there have been cases where governments, both state and federal level, have acted as amicus curiae. But there's not many, I think, in other jurisdictions. But if you can get the cooperation of government, then it is far easier to get the information which you need and then the evidence. But I think there is a downside to that. And of course, as soon as you involve government, then obviously there are issues of political accountability and so on and so forth. And of course, given the length of time these cases take, you are likely to see at least one change of government. And this has been a real issue out of Africa. Good, okay.
Ed, would you like to come up? Are you here somewhere? I'd just like to thank Professor Barry Ryder on behalf of all of us for his comments and his insight. Barry, thank you very much.
Professor Ryder, thank you. It's been an honor to have you here in Beirut, and we would like, in the name of ICC FRAUDNET, to give you a token of recognition from Lebanon. It's the first alphabet, we think, in the world, the first phonetic alphabet, the Phoenician alphabet.
Five-minute break, everybody, and then we're back for the next session. Thank you.